Welcome back. Today we're digging into a case that honestly reads less like a legal document and more like a multi-generational family drama.
It really does. We're looking at Doddamuniyappa versus Muniswamy, and it raises this huge question about ancient birthrights clashing with modern deals.
So our mission today is pretty straightforward.
Mm-hmm.
Can a father fight to win back family land and then just trade it away?
Uh-huh.
Or do his children have some kind of invisible veto power?
And it all kicks off with one family, the Chicana family, way back in the 1950s.
Okay, so let's walk through the timeline. A grandfather leaves land to his 3 sons. In 1950, those sons sell it. But, and this is the key, they put in a buyback clause.
A reconveyance clause, basically saying, we reserve the right to buy this back from you down the line.
Decades go by. They finally go to court to enforce that right. And in 1974, they win. The land is back in the family.
But that's where the victory becomes a problem. Just 2 years later, in 1976, those same sons, who are now fathers, get into another dispute and sign a compromise.
They agree to give away a piece of that land they just fought so hard for.
And crucially, they don't tell their own sons, the grandsons of the original owner. That's the secret deal that sparks this whole thing.
So you have this immediate conflict. The purchaser who got the land in the compromise says, look, the ancestral link was broken back in 1950.
Right. Their argument is that when the fathers got the land back in 74, it was through their own effort. It was new property, self-acquired.
Which would mean they could do whatever they wanted with it, right?
Exactly. But the grandsons had a totally different view. They said that the right to buy the land back was an ancestral asset all along.
So the land they came from exercising that right must also be ancestral.
And the Supreme Court, they actually sided with the grandsons. This is where we get into that legal concept of reconveyance.
Okay, so what does that mean in plain English?
It means the land didn't come back as a blank slate. Because it returned based on a condition tied to the original ancestral title, the court said the property just reassumed its original character.
So it's not a fresh start. It's more like it just snapped back to what it was before.
Precisely. And this is all based on a really important precedent called the depot principle.
The depot principle, what does that establish?
It draws a very clear line. Under Hindu law, property you inherit from your father, grandfather, or great-grandfather isn't just yours. You hold it jointly with your own sons. You're all co-parceners.
Okay, and that's the aha moment here. The difference between property you buy with your own money versus land that's passed down.
Yes. So the second that land was reconveyed to the fathers in 1974, it wasn't just their land. It instantly became joint family property again.
Meaning the grandson's rights snapped into existence at that very moment.
Immediately, they became co-owners by birthright, which means the fatal error in 1976 was the fathers trying to sign a compromise by themselves.
They were trying to give away rights that already belonged to their children.
You can't give away what isn't fully yours. Since the grandsons were co-parceners, their consent was mandatory. The deal was invalid as far as their shares were concerned.
Wow, that's a huge ripple effect. A settlement that a parent makes to end a long, messy dispute can just be undone.
Decades later, yes. For any legal pros listening, this is a major warning sign about execution proceedings. When you're finalizing that transfer,
You can't cut corners.
you have to get consent from every single co-parcener, every heir, or the whole agreement is built on shaky ground.
And for families, it's a clear warning. A convenient settlement that leaves out your kids might just be kicking the can down the road. You're planting a time bomb.
It creates this real tension, doesn't it? The need for certainty in deals versus protecting a family's legacy from a bad decision by one generation.
It really does. Which leaves us with a final thought for you to chew on. We think that when we win a fight, we own the spoils. But is it fair that a father's attempt to settle a dispute can be torpedoed by his sons years later?
Or is that birthright protection the only thing that truly preserves a family's assets across generations?
That is the question. Thanks for joining us on this deep dive. We'll catch you on the next one.